It began as an ordinary courtroom proceeding, the kind that rarely garners national attention or inspires spirited commentary beyond legal circles. But on this particular day, in a packed courtroom with fluorescent lights glaring from above and wooden benches creaking under the weight of curiosity, a seemingly minor incident would ignite a nationwide debate about freedom of expression, the competence of the judiciary, and the power of knowledge in the hands of the underestimated. Karoline Leavitt, a rising star in conservative political circles and known for her articulate defenses of constitutional principles, found herself in court not for a major violation of the law but for something far more symbolic, wearing a modest cross necklace that peeked through her blouse during a municipal hearing. The presiding judge, clearly distracted by the optics rather than the substance, deemed it inappropriate and issued a fine under the premise of maintaining religious neutrality within the courtroom. What the judge didn't anticipate, however, was that Karoline would not only contest the fine, but do so by leveraging a deep and nuanced understanding of constitutional law that would ultimately turn the proceeding into a full-scale masterclass. Spectators, attorneys, clerks, and even opposing counsel watched in increasing disbelief as the narrative transformed from an alleged breach of decorum into a lesson in civil liberties that peeled back layers of judicial bias and ignorance. The courtroom, once marked by a strict and unquestioned hierarchy, began to feel like a classroom in which the student had far outpaced the teacher, not with arrogance, but with precision, precedent, and principle. As Karoline stood to address the court, there was a distinct shift in atmosphere, a tension thick enough to be sliced with a knife. She did not raise her voice, nor did she indulge in grandstanding. But the confidence with which she laid out her opening statements had an almost gravitational pull, starting with the First Amendment and threading through case law ranging from Tinker v. Des Moines to Burwell v. Hobby Lobby. She outlined how personal religious expression, when non-disruptive and non-proselytizing, is constitutionally protected, even in settings of supposed neutrality. The judge, visibly flustered, attempted to interject multiple times, citing outdated administrative orders and vaguely worded decorum rules. But Karoline had anticipated every counterpoint. She produced judicial opinions from circuits across the country that systematically dismantled the judge's rationale, noting that decorum could not supersede rights granted by the highest law of the land. At one point, she cited a little-known appellate ruling that held that even judges could not create a religiously sterilized courtroom absent a clear, demonstrable threat to order. The judge, realizing he was outmatched not by another lawyer but by the very defendant he had fined, tried to reframe the argument as a mere misunderstanding. But by then, the damage had been done. Reporters in the back row began furiously taking notes, while legal bloggers live-tweeted the exchange with hashtags like #CarolineCrossCase and #LegalClinicLive. In a span of just 30 minutes, the courtroom transformed into an arena of ideological reckoning, and Karoline, with her cross still glinting in the courtroom light, was emerging as a symbol of both faith and legal intellect. The ramifications of Karoline's legal takedown were almost immediate. As clips of her statements circulated on social media and were replayed on news programs across the political spectrum, public opinion quickly polarized. Civil liberties advocates praised her for standing firm, while even some left-leaning commentators conceded that the judge's fine had been an overreach. Within 24 hours, legal analysts on cable networks were dissecting her arguments line by line, marveling not only at her composure, but at the depth of her jurisprudential knowledge. It came to light that Karoline had interned at the Department of Justice during her undergraduate years and had spent considerable time studying constitutional law independently. While pursuing her journalism and communications career, what appeared to the judge, as mere audacity, was, in fact, the culmination of years of quiet, rigorous preparation. More astonishing was how Karoline didn't merely rely on emotional appeals or vague invocations of rights, but rather on precise legal architecture that forced even seasoned attorneys to revisit their own understanding of religious liberties. Bar associations began discussing the case in newsletters, and constitutional scholars were invited on radio shows to debate whether the fine itself was potentially a violation of federal law. Meanwhile, in conservative media, Karoline was hailed as a heroine who had exposed how institutional authority could be blind to the very freedoms it was meant to protect. Editorials called it a moment of judicial reckoning, and overnight, Karoline's name became synonymous not just with resistance, but with the empowerment that comes from knowing the law better than those who wield it. As the media storm intensified, the judge who issued the fine began facing scrutiny from multiple directions. The State Bar Association launched an internal review of his conduct. It's not just for the fine itself, but for what appeared to be a pattern of questionable rulings involving expressions of personal belief in courtrooms over the past year. Former defendants and attorneys came forward, sharing anecdotes that painted a picture of a judge who often conflated personal preference with legal authority. Some alleged that he had previously reprimanded individuals for wearing religious insignia or clothing, citing an ambiguous interpretation of neutrality. Legal watchdog groups seized the opportunity to push for more clarity and reform regarding judicial conduct codes, especially concerning religious expression. Meanwhile, Karoline maintained a calm public demeanor, declining offers from television producers eager to exploit the moment. Instead, she gave a few carefully measured interviews, emphasizing that her intention had never been to embarrass the judge, but to correct an injustice. She reiterated that courtroom decorum should never be used as a weapon against individual rights, and that every American, regardless of background, deserves a judiciary that respects the Constitution above all else. Her poise in these interviews only added to her credibility. By contrast, the judge's responses, when offered, were awkward and defensive. He released a short statement insisting that he acted in good faith and within precedent, but it failed to resonate. Even colleagues within the legal community began to distance themselves, recognizing that whether intentionally or not, the judge had become a symbol of institutional overreach, a role he had neither anticipated nor could now escape. Behind the scenes, political operatives began to take notice of Karoline's meteoric rise. Not only had she held her ground in a legal confrontation, but she had also done so with such composure and sophistication that she was now seen as a formidable future candidate for higher office. Rumors swirled that several think tanks and advocacy groups had approached her with speaking engagements and book deals. Eager to capitalize on the moment, Karoline appeared to remain focused not on opportunism, but on using the spotlight to raise awareness about broader constitutional issues. She launched a campaign encouraging young people, especially those in underrepresented communities, to educate themselves on their rights, asserting that knowledge of the Constitution should not be reserved for lawyers alone. She called the initiative Know Your Liberty, and within days, it had gone viral. Educational toolkits, videos, and annotated readings of landmark Supreme Court decisions began circulating, all presented in a clear and digestible format. What began as a personal legal dispute had evolved into a grassroots legal literacy movement. Students, activists, and even public school teachers began incorporating her materials into lesson plans. The impact was so swift and far-reaching that even lawmakers began referencing her initiative during legislative sessions. Karoline's refusal to let the courtroom incident define her through outrage alone, and her choice to instead turn it into an educational crusade, cemented her status not just as a political figure, but as a civic educator and reformer. It became increasingly clear that the judge's attempted silencing had produced the exact opposite effect. He had unintentionally amplified a voice that was now resonating across the nation. As weeks passed and national interest in the case continued to swell, the judicial system itself responded with a rare mixture of humility and reform. A state judicial commission issued a public report acknowledging deficiencies in how courtroom decorum policies were applied in relation to constitutional rights. While they stopped short of censuring the judge directly, the report was a clear indictment of a system that allowed personal bias to masquerade as legal authority. New training modules were introduced for judges across the state, emphasizing the importance of distinguishing between maintaining order and infringing upon individual liberties. In an even more unexpected development, the state's Supreme Court invited Karoline to participate in a forum on courtroom ethics and constitutional boundaries. Her address at the event was delivered with the same clarity and conviction she had displayed in her original courtroom defense, earned a standing ovation from an audience composed primarily of judges, clerks, and legal educators. Several justices privately thanked her for illuminating blind spots in their institutional framework. It was a moment of extraordinary irony. The very individual who had been fined for a symbol of her faith, the rights that faith symbol represented, and all this without holding a formal law degree. Her ability to bridge the gap between the legal elite and everyday citizens turned her into a transformative figure, someone who neither vilified the law nor bowed to it blindly, but instead demanded that it serve its highest purpose, the preservation of liberty for all, in the broader cultural landscape. Karoline's story triggered an overdue conversation about the subtle ways in which authority figures often exercise power without proper accountability. Across social media platforms, thousands of individuals shared their own experiences of being silenced, dismissed, or penalized in educational, legal, or governmental settings under the pretext of policy or professionalism, experiences that, when scrutinized, revealed a consistent pattern of rights being curtailed for the sake of order. Hashtags like #Constitution over convenience and #MyRightsToo began trending, sparking grassroots discussions not only in legal forums but also in churches, schools, universities, and coffee shops. For many, Karoline had become a symbol of what it meant to resist institutional overreach without abandoning civility or the law itself. Conservative commentators amplified the story as evidence of a judiciary increasingly out of step with foundational freedoms, while even some moderate voices acknowledged the case highlighted legitimate gaps in judicial awareness. Meanwhile, legal faculties across several universities invited Karoline to participate in symposiums and debates, not as a token political figure, but as a substantive contributor to discourse. One notable moment occurred during a televised panel discussion at a major law school where Karoline engaged in a respectful yet pointed exchange with a former federal judge. Her ability to argue case law while drawing from real-life implications impressed not only the panelists, but viewers nationwide, many of whom had begun following her as a daily source of insight. By this point, Karoline was no longer merely reacting to an event, she was shaping its legacy. And the judge who had attempted to fine her into silence found himself a footnote in a story far greater than his own misstep. In the end, what began as a modest courtroom conflict evolved into a defining episode of civic awakening. The judge, after months of scrutiny, quietly stepped down, citing a desire to spend more time with family, though insiders knew his departure had more to do with reputational damage than retirement aspirations. Karoline, on the other hand, continued to rise not as a media darling, but as a force of calm persistence, legal clarity, and principled conviction. She published a book, modest in tone, but rich in content, titled Worn with Honor, Liberty, Faith, and the Power of Knowing the Law. It became a bestseller not because it offered bombastic rhetoric, but because it tapped into a widespread hunger for civic understanding in an age of institutional mistrust. Schools, advocacy groups, and even law enforcement agencies began recommending the book to new recruits and students. In Congress, a bipartisan group introduced the Courtroom Clarity Act, aimed at providing uniform guidelines that balance courtroom decorum with constitutional protections legislation that cited Karoline's case in its introduction. For her part, Karoline remained wary of partisan exploitation, repeatedly insisting that the issue was not about left or right, but about right and wrong. And perhaps that is why her story endured. It reminded Americans that the Constitution is not merely a document of the past, but a living contract, one that empowers individuals to challenge power when it veers off course, by standing her ground with dignity and intellect. Karoline didn't just win a legal argument, she reignited a national conversation about the sacred balance between order and freedom. and long after the courtroom lights dimmed and the judge's gavel fell silent. Her cross remained not just on her neck, but in the hearts of millions who had been reminded that one voice, when anchored in truth, can recalibrate even the scales of justice.